Nick Stearns, and I'm one of the co-founders of You Do It Legal. I also happen to be a lawyer. Specifically, I'm a certified family law specialist, which is a credential that I received from the California State Bar's Board of Legal Specialization. I've also been a practicing family law trial attorney for over the past 30 years. Let me tell you about You Do It Legal. In the 30 plus years that I've been going into family law courtrooms, I've witnessed literally thousands of individuals representing themselves fail. And the reason that they failed wasn't because for what they were asking wasn't legally justified or appropriate. Rather, they failed because either they didn't prepare, file, and serve the required court forms and documents, or they didn't follow the correct court procedures or processes, or they failed to provide to the court critical information, evidence that the court needed in order to consider the request. I didn't think that was fair, so that's why we created You Do It Legal. You Do It Legal is what we call a legal information and resource provider. Through our software, we inform you of the court documents and forms that need to be prepared, filed, and served. We inform you of the court processes and procedures that need to be filed, and we inform you of the information, the evidence that the court requires in order to consider your request. With our software, we also prepare for you the court forms and documents that need to be filed with the court and served on the other party. We also provide you instructions on how to file your documents with the court and how to serve those documents on the other party. Now, whether your particular request will be granted, that depends entirely on the facts and circumstances of your case. However, with our help, with You Do It Legal, we can get you into court so that you can be heard. In this video, we're going to take you through what we call a roadmap for requesting a domestic violence restraining order in California. We're going to go through each step of what's involved with that request. So here we go. Step 1, court form preparation and filing. With your request, there are specific court forms and documents that need to be prepared and filed with the court. Now, by filing, I mean that these documents need to be delivered to the courthouse, given to the clerk of court, so that they make their way to the judge so that your request can be considered. With our software, we identify for you those court forms and documents that need to be prepared and filed with the court. Step 2, serving the other party. Once you file your court forms and you have a hearing date on your request for a domestic violence restraining order, the next step is to get the other party served. Now, what that means is that your court forms with the information on which you're basing your request for a domestic violence restraining order and the date, time, and place of your hearing, those documents must actually be handed to the other party. Now, the individuals who can do the service for you are a close friend or a member of your family, law enforcement, the sheriff, or a professional process server. A condition for those individuals is that they must be 18 years old or older. Now, let me tell you who cannot serve your papers, and that is you, a party of the case, or anybody else who is a protected individual or for whom you're requesting protection under your request for a domestic violence restraining order. Step 3, the other party's response. After you have served the other party with your request and the information supporting your request for a domestic violence restraining order, that party then has the opportunity to file with court and serve on you a response to your request. In that response, this individual can either agree or disagree with the orders that you're requesting, request additional orders that you haven't requested, and request a continuance of the scheduled hearing date. Lastly, know this. The other side might not file a response or serve you with it. In other words, they might just show up to court and you will hear then and there for the first time what they want. So be prepared for this possibility. Step 4, the court hearing. It's at the court hearing where the judge will decide whether to grant or deny your request for a domestic violence restraining order. It's at this hearing where the judge will go over with you and the other side the papers you've both filed in support or in opposition to the request for domestic violence restraining order. It's here where the judge might hear testimony from you, testimony from the other side, which means hearing your story, hearing the other side's story regarding what occurred. The court might also receive other evidence, documents, emails, pictures to consider the request. The court will then decide whether to grant or deny your request. Now, if your request is granted, a domestic violence restraining order will issue, which is also called a restraining order after hearing. Now, be aware of this. Oftentimes, your request for a domestic violence restraining order takes multiple hearings, so you might be asked to come back to court again. Step 5, enforcing a restraining order. If your request for a domestic violence restraining order is granted, the order then needs to be enforced. Now, the court will provide a copy to law enforcement so that the restraining order can be enforced. But to make sure that there are no problems with enforcement, you should have a copy of the restraining order together with the proof of service of the restraining order on the other party on you at all times. Any other person also protected under that restraining order should also have those same documents. Additionally, a copy of that restraining order with the proof of service should be at any location that the restrained person is prohibited from going, such as your home, work, your children's school, or any other place. Step 6, ending, modifying, or renewing. If your request for a domestic violence restraining order has been granted, know that if the circumstances later arise, you can terminate it, end it, or have it modified. Also, if your restraining order is about to come to an end and you think circumstances justify it being renewed, you can also do that with court. Okay, now that we've gone through the steps related to a domestic violence restraining order, we're going to go through some additional considerations. Costs. You need to be aware that if you file a request for a domestic violence restraining order, certain costs might be incurred. Now, first, there are no filing fees to request a domestic violence restraining order. Those fees are waived. However, you might incur some service costs. Specifically, if you hire a professional process server to serve your documents, fees will be incurred. Next, you need to be aware of the possibility that the court can order attorney's fees being awarded to a party. If you request a domestic violence restraining order and you do not win, and the other side has hired an attorney, the court then can order you to pay the attorney's fees and costs incurred by the other side. You also need to be aware that there are what we call indirect costs associated with requesting a domestic violence restraining order. Specifically, you need to factor in that you're going to need to take time off of work, or if you have children, you're going to have to arrange for childcare. Professionals and other important individuals. Out-of-court personnel. Now, there are 3 individuals that you should be aware of in this category. The first is the mediator. This is a mental health professional that's been trained to assist you and the other side if you have a dispute regarding custody and visitation. The next is the family law facilitator. This is an individual who is there to provide you information regarding the court processes and procedures or other information that the court needs in order to decide your case. Lastly, there's the clerk of court. Now, this is the individual who is situated in a separate office where you file your court papers. In-court personnel. In court, you're going to meet 3 individuals. First, you're going to meet the court clerk, who's the individual that manages the courtroom and manages the cases that are going to be heard that day. Oftentimes, you will check in with the court clerk on your case. Then there's the bailiff. The bailiff is a law enforcement officer. He or she is in court to make sure that everything goes peacefully. Lastly, there's the judge, also known as the judicial officer. This is the individual who's going to hear your case and decide whether to grant or deny your request for a domestic violence restraining order. Wellness professionals. This basically falls into two categories. One is a domestic violence victims advocate. Now, this is an individual that you can find through a shelter or other organizations that help individuals who have suffered domestic violence. These people can appear with you in court to provide support, but they cannot talk or address the court. The next is a therapist or psychiatrist. This is a mental health professional who can assist you in coping with the abuse that you've suffered in domestic violence. Other law-related individuals. First, law enforcement officers. We're talking about the police or the sheriff. These are individuals who can come and protect you if you believe you're the victim of domestic violence. They're also the individuals who can enforce a domestic violence restraining order if one is issued. Next, process servers. These are the individuals who serve on the other side your request for a domestic violence restraining order. They can be friends or family, they can be law enforcement officers, or they can be professional process servers. Lastly, attorneys or lawyers. These are professionals that you can hire either to represent you in a request for a domestic violence restraining order, or that the other side can hire to oppose your request to a domestic violence restraining order. Restraining and protective orders. All right, here we're going to discuss and go over the 8 types of orders that are available if you believe you've suffered abuse and you want to seek help and assistance from court. The first order we have is a temporary restraining order. When you file for a request for a domestic violence restraining order, the court can issue a temporary restraining order. Now, this is an order that is designed to give you immediate protection up until the date of the hearing on the permanent order. So whatever relief you ask for, rather, whatever orders you're asking, will be in place up until the time of your hearing. That's generally 20 to 25 days. Next, domestic violence restraining orders, also known as restraining orders after hearing. These orders are designed to protect individuals who have suffered domestic violence from further abuse. The difference between this type of order and a temporary restraining order is that this order is considered permanent and can be issued for up to 5 years. Next, criminal protective orders. These are orders designed to protect individuals who have been a victim of a crime. Now, these orders can only be issued by a criminal court and can be valid up to 10 years. Emergency protective orders. This is an order that is issued at the request of a law enforcement officer to a judge. The condition for this type of order being issued is that the law enforcement officer must believe that the victim is in the immediate and present danger of violence. Now, these orders are valid up to 21 days and can be issued at any time, 24/7. Now, generally speaking, this type of order is typically obtained first by an individual who has suffered domestic violence and can also provide enough time to allow that individual to apply for a domestic violence restraining order. Next, civil harassment restraining orders. This type of order is issued in a non-domestic violence situation and can be issued to anyone 12 years of age or older who believes that he or she have been harassed, stalked, sexually assaulted, or threatened with violence. Now, we are typically talking about a situation where conduct like that has been committed by a roommate, a neighbor, or perhaps a coworker. These orders can be valid up to 3 years. Next, elder abuse restraining orders. This order is designed to protect individuals who are 65 years of age or older. Now, the types of abuse that this order is designed to prevent is as follows: physical abuse, financial abuse, mental or emotional abuse, neglect, abandonment, isolation, or mistreatment by a caregiver. And that caregiver can either be a family member, a friend, or a professional caregiver. These restraining orders are good for 1 to 5 years. Next, workplace violence restraining orders. Now, this type of order is designed to protect employees of a business. Specifically, it is designed to prevent abuse, harassment, stalking, and violence. Note that this type of order can only be requested by the employer and is designed to protect all employees of that business. Next, gun violence restraining orders. The purpose behind this type of order is to prevent an individual from buying, owning, or having in his or her possession a gun, firearm, parts of a gun, ammunition, and magazines. Now, a judge can issue this type of order to 5 types of individuals, and we have listed them in the attached slide. In this segment, we're going to address abuse, specifically what abuse is under the California Family Code as well as the California Penal Code, and we'll also address how individuals such as domestic violence advocates define abuse. Safety planning resources. Now, developing a safety plan is something that falls outside the scope of what You Do It Legal can do for you. However, as indicated in this segment, we've identified 2 groups that can assist you with developing a safety plan. Additional resources. If you're a victim of domestic violence, we recognize that beyond seeking help from the court, you most likely need support from others. In this slide, we identify 3 other groups that can provide you support. That's it. That is You Do It Legal's roadmap to requesting a domestic violence restraining order in California. We hope it's been informative, and I want to thank you for your time. And as always, if there's anything else you need, just let us know, and we'll do our best to help you.